Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for nearly a decade. You can find me on all social platforms at Joshua Ritter ESQ or at joshuaritter.com. We are recording this on Wednesday, July 30th, 2025. In this week's episode, attorneys seek to dismiss murder charges against a Massachusetts man accused of killing and dismembering his wife. Plus, an Arkansas father charged with chasing down and shooting his teenage daughter's alleged abuser. But first, we have breaking news as the jury has reached a verdict in the murder trial of a Colorado dentist accused of fatally poisoning his wife. Today, we're joined by Donna Rotunno, a criminal defense attorney, legal analyst, Fox News contributor, and a good friend. Donna, how are you doing?
Great, Josh. How are you? It's so fun to be with you today.
I know, this is a treat. I've been looking forward to this. And we planned it, of course, to coincide exactly when we just got a verdict in this case that you and I have been following closely.
Amazing that happened, and I'm all fired up to talk about it because
good. I'm glad to hear it.
This case has just gotten to me from the very beginning. So
I know.
I actually wish it got even more press than it has, and I think it would have been really interesting if there were a live stream of this one for everyone to see.
It's a little frustrating, and I agree with you, because we get a lot of these types of cases involving, spouses killing other spouses, but this one seems to have a sprinkling of extra sauce on top of it that we can get into. Let's jump right into it. In fact, out of Denver, Colorado, moments before we sat down to record this episode, Colorado dentist James Craig was found guilty for the fatal poisoning of his wife, Angela, in 2023. Prosecutors argued that Craig made multiple attempts to kill his wife, Angela, before she passed away from a lethal dose of cyanide and tetrahydrozoline. The dentist was allegedly in financial straits at the time of Angela's death and feared the repercussions of divorcing the mother of his 6 children, despite his numerous affairs. Craig's defense claimed that he had his infidelities, but maintained that Angela caused her own death after years of an unhappy marriage. Craig's defense also alleged that authorities in the case were narrowly focused, insisting that the man was the victim of a quote-unquote broken investigation. In addition to the murder charges, Craig faced multiple charges for attempting to tamper with or fabricate evidence, and even trying to have an investigator in the case killed, all while Craig was behind bars. While his defense claims these were the actions of a scared, innocent man, this argument did not persuade jurors who convicted the man of murder in the first degree, solicitation to commit murder in the first degree, solicitation to commit perjury, and solicitation to commit evidence tampering. That is a mouthful. First of all, Donna, I'm just going to let you jump right in. What is your reaction to this verdict?
Well, first of all, my reaction is the jury got it right. And I know people are talking about the fact that this was such a clear-cut case. The jury shouldn't have even taken this long. I mean, I think the jury did their job. Give them credit. They read the jury instructions. They probably went through count by count and went through the evidence before they took votes. And so I give them a lot of credit. Clearly, they didn't have any trouble getting 2 guilty verdicts on 6 counts. They did not, in any form that I know, ask any questions. They didn't come out and need any clarification. It didn't seem like they were struggling even with one holdout. So I think this was a home run in terms of prosecution in this case. I think the defense fell absolutely flat. And, when you brought up all the defenses that he was trying to raise, I kept thinking about it. And, for you and I that try these cases, you sit down and you look at, what is my likelihood of being successful? And I understand that sometimes you say, okay, we have a really bad case and we're grasping at straws. But to me, this was almost an insulting defense to the point where it turned people off probably more than they would have been just from the facts of the case itself. So, I don't think he was winning this case regardless. So, in that vein, I guess you throw everything at the wall and see what sticks. But I looked at this and I thought he was the only person who could attest to any of these defenses that they tried to raise. I mean, you did not have one witness. You did not have one piece of evidence that could corroborate in any way what he was trying to claim about her mental health, her desire to harm herself, excuse me. If you looked at any of her text messages, her Google searches, nothing showed in any way, shape, or form that she was trying to harm herself. She was trying to figure out what was wrong with her. I mean, she would have had to have been the most diabolical, calculated human being on earth for anybody to believe that she took part in her death in any way. So I just think this defense fell
I
flat.
think that's an excellent assessment of the defense and an excellent segue into my next question, being that he is the only one that could attest to these things. Why didn't he testify? It really did seem like a Hail Mary of a defense. And I agree with you. It was almost insulting to jurors to really try to blame this on the victim, but then with really nothing to support it. So you're just kind of beating up the victim for no reason that's helpful to you. And you know, I've said many times, and we've talked about this, that sometimes, even though it's an awful defense and you can criticize the defense attorney, they have to kind of say something. Well, here, sure, they could have done that by putting their client on and put him on. Listen, I know he's got a constitutional right to refuse that, but it seems like if this is what you were going for, your best shot would have been have him make a personal plea to the jury. Were you surprised that he didn't take the stand?
Yeah, I think in this case, the evidence was so stacked against him and his problem in taking the stand. And I agree with you. In these cases, it's just like a self-defense case, right? If you are in fear of your life, the jury needs to hear that from you, because obviously in that situation, there's no doubt as to who committed the killing. So you have to convince the jury that you felt that you were in such danger that you had to protect yourself. So in this case, I think you're right. He would have been the only person to be able to attest to that. I think the problem they would run into is put him on the witness stand. And even if they think he could be charming or he could make headway, or he would still have to answer to his text messages. He would still have to answer to his searches on his computer. He would still have to answer to the way that he spoke to his partner. There's all of these things, and he would have to speak to the affairs that were going on. At the same time, he's allegedly trying to take care of this wife and telling her, I want to be with you. And all the messages that went back to Christmas time saying, no, we need to stay together. And then in February, he's meeting this woman. I mean, there was just so many things. I mean, you could have cross-examined him for 2 days based on the evidence against him. So I feel like as much as maybe they could or should have, the negative outcomes from that could have been so much worse. I think a good prosecutor and a good person who could cross-examine would just, obliterate him, honestly.
Yeah,
it would have been fun. I would have loved that. You're right. No,
it would have made for good television, but you're right. It probably would not have made for a great defense. And the other thing, as defense attorneys, we know this, doesn't mean they didn't think about it. Doesn't mean they didn't sit down with him and put him through some mock cross-examinations. And it could be that when you're dealing with an absolutely evil narcissist like this, he just comes across as incredibly unlikable anyways. And maybe just putting him up there, to your point, not only could he not answer these questions, but he would have just made it easier for jurors to convict him just from hearing him talk about these things. That's all speculation on my part, but I oftentimes think about that. We don't think about how difficult it is for someone to testify even when they're a likable person, when they're not, and they're a narcissist like this gentleman is. I'm no psychologist, but I'll call it as I see it. Mm-hmm. I think that you could easily turn off jurors even further. Let's talk about a couple of highlights from this case, though. And there were many, but something that stood out to me was one, his own daughter took the stand against him and talked about how he had sent this letter. And it was, to me, just heartbreaking to think about what he's not only put them through by killing their mother, but now he's sending this letter to his daughter, asking her to fabricate evidence with this deep fake video of the mom. Do you think that was something that jurors found impactful as I did?
No question. I mean, first of all, how do you not feel for 6 children, and I know some of them are older, but that are left motherless? I mean, this is, and not only are you left motherless, but you're left motherless at the hands of your father, and you're left motherless watching her suffer the last couple of weeks of her life, not knowing what was wrong with her and the torture in her mind. I mean, just horrific. So all of these things combined, right? And then to victimize the victim daughter further was like the lowest of the low. And the fact that she got up there and testified, and now she has to testify against her dad who killed her mom. I mean, it's like a Hollywood movie.
Yeah. Yeah.
Awful. But unfortunately for them, it's their real life and they've had to
Yeah.
live it. And now they've lost their mom. And I'm sure at some point, before they knew all the evidence, obviously she was talking to her father. So they had some kind of a relationship. So I'm sure they were confused as to how all of this went down. And I mean, just an awful situation to be in for those kids. Awful.
Their whole life ruined, like you said.
Yes.
Mother lost, father lost. Who knows what the relationship
Yes.
they had with him, but now he's off to prison for the rest of his life. Really awful stuff. You're right. Last thing on this, he was convicted for 7 counts, and 6 of those 7 happened to do with things that crimes he committed since he was arrested. And I'm curious to hear your thoughts on this, because I feel like in these types of situations, jurors can understand the concept of a innocent person being accused of a crime. They can understand that, yes, there is this situation where people get accused of something and they're simply not guilty of it. But then they put themselves in the position of the defendant and they go, how would I react? And how would I behave having been accused as an innocent person of this crime? And when you have a person like Craig, who gets accused of a crime, gets arrested, and then starts to try to fabricate evidence, starts to try to plant evidence, starts to try to plan the murder of the lead investigator. This, to me, might be even more convincing evidence of his guilt than anything else. But what were your thoughts?
Yeah, I agree with you. First of all, I always call it standing in your own way. Anytime you have a client that stands in his own way, let's say that none of the post-arrest issues took place and it was just the murder of his wife and he didn't try to do all this band-aiding. And I think the problem was trying to tamper with evidence, trying to remove people out of the case, puts you in a situation where you look even more guilty now for what you're initially charged with. So that's number one, not even talking about what you're guilty of after the fact. But let's say none of that happened. At that point, his defense team could then argue a situation where poor investigation, because there was a lot of things in this case the police could have done better. Now, fortunately for them, the evidence was very overwhelming and those issues didn't play as front and center as they may have if the evidence was not as strong. But, without all these things after the fact and other things for the government to focus on, they may have had a completely different case in terms of being able to argue that, yeah, you may think he's the bad guy, he's horrible, he cheated on his wife, but there's a lot of things that they can't prove here or that they should have done to make you more comfortable with this verdict. And so, I think what he did after the fact not only made him look more guilty, but it absolutely sealed the deal. I mean, it just, and it sealed his fate in the sense that he's never going to see the light of day.
Yeah. Really remarkable person in how desperate he was, how sad, frustrated, selfish, narcissistic he was.
Just get a divorce. I mean, it's like, okay, it's going to be expensive, but now you have no life and you have no freedom. There's nothing more expensive than that.
They just don't think the way that we do. They just don't process things. They think they're going to get away with it. Let's turn from that case to another horrible case of a husband murdering his wife out of Dedham, Massachusetts, where defense attorneys for a man charged with the murder and dismemberment of his wife are seeking to dismiss a first-degree murder count, claiming that prosecutors have insufficient evidence to support premeditation. Authorities believe Brian Walshe killed his wife Anna sometime between January 1st of 2023 before disposing of her body, which has still never been found. Lawyers for Walshe argue that prosecutors did not present enough evidence to prosecute Walshe under a theory of first-degree murder as a murder committed with extreme atrocity and cruelty. As a result, they assert the portion of the first-degree indictment against Walshe that accuses him of extreme atrocity and cruelty should be tossed out. Judge Diane Frenier questioned whether she had the authority to dismiss one theory of first-degree murder, suggesting that might be an issue more appropriately raised at trial. While Walsh's defense waits for a judge's determination on the dismissal of the first-degree murder charge, both sides continue to fight over digital evidence ahead of Walsh's trial scheduled for October 20th. Donna, help us understand this idea about theories and how they're different from, say, the charge or the degree of the charge, because what's happening here is the defense is saying that one of the theories being used by the prosecution to arrive at first degree, they don't feel is supported. And the judge sounds like she's leaning in the direction of saying, well, hey, that's kind of up to the prosecution, not really something for me to decide. What are your thoughts on that?
I agree with the judge. I think the problem, and I'm all for all pretrial motions that you can file that are meritorious, that are brought in good faith. But here's the problem in this case, and I think it's very specific to these facts. You're basically admitting that he is potentially guilty of something lesser than the count you are trying to have dismissed. So to me, if you are trying to dismiss an indictment, you are better off going in and trying to dismiss an entire indictment for lack of evidence, right? So by going in and only pinpointing one count and saying you have a lack of evidence and your theory doesn't support it, you're highlighting the fact that maybe he is already guilty of the other thing. So I don't know if I necessarily love that strategy, but I think the judge is correct in the sense that you don't get to determine whether cases get dismissed on a motion to dismiss based on not believing the prosecutor can meet their burden with their theory. It has to be under the facts of the case. And obviously, as we know, first degree, especially here, talking about, evidence to support premeditation, that's going to come out at trial. Those are issues that come out at trial. And that's for a finder of fact at a trial, whether that's a judge or a jury, to determine whether or not the prosecutor can meet that burden beyond a reasonable doubt. So I'm not so sure I love the strategy. I understand it in the sense that you want to try to have the most serious counts dismissed, but I'm not so sure it accomplishes what they are trying to accomplish.
Yeah. Yeah, sure. Go for it. Be creative, be aggressive, be zealous on behalf of your client. But I do agree with you that this, jurors don't even necessarily have to agree on the theory. They have to agree on the elements of the charge. They have to agree that everybody's guilty, but they don't necessarily have to agree on the theory presented by the prosecution in order to get them there. So an interesting argument, but it doesn't sound like the judge is leaning entirely in their favor. One other wrinkle about this case that people have been talking quite a bit about, and if you haven't been living under a true crime rock, you understand that this case has at least a tangential connection to the Karen Reed case out of Massachusetts as well, because the lead investigator on that case is the same who was the lead investigator on this case, and that is disgraced state trooper Michael Proctor, who was removed from his post largely in part to his work on the Karen Reed case and misconduct that they felt that he had on that case. As a defense attorney, how do you think they use that here? Because it's a totally different case, yet the same detective. What is the defense? What do you imagine them trying to do with that type of information in this Brian Walshe case?
Well, I think what they'll do is they will file pretrial motions after they get rulings on the ones that are currently pending. I think they will file, if they haven't already, file pretrial motions to determine whether or not they can get into these aspects from Karen Reed, because they're going to want to attack his credibility. And they're going to want to say, this is not a credible person, and you can't believe what he's done here, and so therefore you can't believe what he's done there. As you know, from being a prosecutor, how many personnel files were subpoenaed or had to be turned over in cases where you're dealing with officers that have, reputations that aren't so great, right? So then the prosecutor has to make the call about, is this the best person for me to call? And as we saw in Karen Reed's second trial, they called different witnesses and they kept certain people off the stand based on the fact that they wanted to stay away from it. So I think here you're going to see how the prosecutor reacts to the pushback of this guy and how upset they really are about his past. If he testifies, if I'm the prosecutor, I front it. Yeah. I bring it up. I don't leave that to the defense to have a field day with, right? I front it. I ask the questions. You look all the way back. I'm going to date myself, but look all the way back to OJ, right? I mean, look at Furman, right? Furman and OJ in some ways was part of the reason that was a not guilty. So you have to be careful as a prosecutor to determine if their benefit outweighs the negativity of putting them up there. And if there's other officers that can testify, they may want to keep them far away. And, then the defense gets to argue to the jury, where's the lead detective? You didn't hear from him. So that'll be a very interesting side point here, and it would
Yeah.
be, and again, you have a no body murder here. I mean, a no body murders are hard to win anyway. I think all they have here is really circumstantial, but it's going to be interesting to see how it plays out.
Yeah. It's funny, 30 years later, and we're still talking about poor Mark Furman and the lessons being learned from him in that case. It's amazing.
I was in college. I was in college listening to the verdict on my Walkman. 'Cause I had my wired headphone in my ear during a class listening to that verdict. So I guess I cared about this stuff all the way back then.
Yeah. Well, I joined the DA's office a good 10 years or so after that. And maybe not. I don't know. I don't want to do the math, but
Probably 20 years.
the reverberations from it were still echoing throughout those halls. I mean, it was people still talked about it in the LADA's offices.
Yes.
You don't want to, you remember OJ. It was like it was happened yesterday.
Well,
Incredible.
even police misconduct here. We've had those officers that were, all the John Burge cases where he was a detective and all those confessions got thrown out. I mean, you still hear about those here, and that was 30 years ago.
Yeah. All right, let's turn to our last case out of Cabot, Arkansas, where the Arkansas Supreme Court has lifted a gag order in a highly controversial case, causing a strong response from the public. Aaron Spencer was charged with second-degree murder in the fatal shooting of Michael Fossler, a man charged with multiple sexual offenses against Spencer's 14-year-old daughter. When Spencer's daughter went missing, Spencer, immediately began searching for Fossler's truck. Soon, Spencer located Fossler and his daughter, and a deadly altercation followed, with Spencer allegedly shooting Fossler. Prosecutors had requested a gag order in the case shortly after Spencer was charged for statements made by the defense criticizing authorities of targeting a heroic father. The recent Supreme Court's ruling will allow the release of some public information in the case and will enable both sides to speak to the media, providing the statements adhere to legal and professional standards. When the case sees a jury, Spencer intends to present a self-defense case, maintaining that the shooting was lawful after the father discovered his missing teenage daughter in Fossler's company. Ahead of Spencer's trial, the father remains out on bail, and we will continue to watch this one as it nears the courtroom. A lot about this case has got people talking, and there's a lot of very strong feelings about this case. But I first want to talk to you about the gag order. I don't know if it's just I'm thinking about it more, but it feels like we're seeing these more. But in a case like this, it was essentially the prosecution wanted to shut it down because they didn't like the criticism they were receiving from the defense and the way that the defense was trying to characterize their client. I don't know how I feel about all of that and these use of gag orders. What are your thoughts? Do you think they're used too often, or do you think they're important and helpful?
Sure. Number one, my first thought is not guilty. That's my first thought.
Yeah,
okay,
right.
so that's number one. That's number one. Number two, that's the reason for the gag order, right? The prosecutors do not ask for gag orders in cases where they think the public is on their side. Right. And that's why these bother me, right? That's why they bother me. And that's why they really are a violation of your First Amendment. It's like, wait a minute, we have a right to criticize this prosecution. Can we say jury nullification? I mean, come on. Do we have a right to say that this is out of bounds, that this father was justified? Yes, you have a right to say all those things. And if they felt the opposite was true, they wouldn't have asked for a gag order. So what I don't like about them is the fact that they are used to shut down a defense when in prosecutions, like think about every high profile case that any one of us has known anything about. The media writes about the cases all day long. And whether it's not the prosecutor themselves, the courtroom prosecutor that's giving information, but people are leaking information to the press all the time, and the press are writing these stories. And then the minute the defense wants to counter the story or give a different narrative, then all of a sudden, it's a gag order. I went through it myself during Weinstein, right? Nobody ever liked what I had to say because it was the only thing that ever talked about fairness or due process or the right to, not guilty, innocent until proven guilty. The minute you bring up the cornerstones, all of a sudden, no one wants to hear from you. So, and then they would send out, Gloria Allred to the microphone every day to be the mouthpiece for the prosecutor. But God forbid, I couldn't say a word. So they bother me. I think they are being used too often. I think that although I believe cases should be tried in a courtroom, I do think that as a prosecutor, when you file charges against someone, you have already ruined their life, right? Their life from that moment on is forever changed. And even, we do it all the time. Even if you get not guilties, it's a lot to come back from. And especially in cases like this or sexual assault cases that have different stigmas. So to me, the least you should be able to do is go out there and maybe not defend your case to the news, but at least defend your reputation.
Yeah, excellent point. It does seem the second charges are filed, the prosecution steps in front of an array of microphones,
Yes.
gives a press conference, tells all the evidence that they have, and then immediately a gag order goes into place and the defense can't say anything about it. I forget who made the famous quote. I wish I did. It would have more of an impact now for me to say it, but there was someone who was acquitted and said, "Where do I go to get my reputation back?"
Yes.
And that's such a good point.
Yes.
Go ahead.
And they're never bringing up exculpatory evidence when they stand in front of those microphones, right? They're bringing up, this is what the evidence will show. And they're never telling you, oh, well, as they did in Koberger, oh, well, we never actually found the knife. And, oh, well, all of the, CYA moments, they're not talking about those. They're just going out there talking about how great their case is and how you're going to prison forever. So, I don't love the gag order. I think that we should be respectful as lawyers, but that gag order, it was like on family member. I mean, it was on everybody under the sun, which I'm not even so sure you have jurisdiction over those people, but that's another argument. But it's one thing to tell the lawyers, what they can and can't do. But I think as long as you adhere to the rules of professional conduct and, you go out and are reasonable and fair about the evidence, I think you should absolutely have a right to do so.
Yeah. Let's get to the case, though, because a lot of people, just even hearing those brief facts that I gave you there, and I know there's probably more nuance to all of this, but you've got a gentleman whose daughter has been abused. She goes missing, and he finds her with her abuser, the man who had been accused of, and I think still facing pending charges against him for abusing her. Something ensues. He ends up shooting. This isn't your traditional self-defense, but defense of others. But even with all, keep your lawyer hat on your head. But how are they going to argue this to a jury? The prosecutors, I'm saying. I just think every, father out there with blood in his veins is going to go, yeah, man. Same thing, man. It's
every
like,
father,
how do they fight
every mother, every
sure.
aunt, every uncle. Yeah, this is a not guilty. I'll just call it right now. This is a not guilty. I am shocked that they charged this case, to be honest. But here, we're seeing this, right? These are the trends we're seeing. We are seeing the good people being charged, and we are watching bad people walk out of jails on, no cash bail and, no accountability for one's actions. And so, I was on in court today on something, and they're talking about this new system where they, it's kind of like a home monitoring. They don't even know where half these people are. Yeah. It's like, oh, great. What a fabulous system. So here we are rewarding this bad behavior. And then here's a guy who's out there defending and protecting his daughter, which is your duty as a father. So I just can't imagine they're going to find one juror anywhere to say that this guy's guilty. I just don't.
Yeah, I'm all for following the law. And I'm all for jurors putting aside their emotions and checking them at the door and following the law. But sometimes I feel like a little bit of what would I do in that situation brought into the room might be helpful for all of us. But you're right. The decision should have been made by the prosecutors to begin with. They're the ones who are the gatekeepers, and they're the ones who can decide. And I feel like it was a mistake to pursue the kind of charges that they did in this case against this man. Yeah.
Yes. Agree.
Donna, this was fantastic, fascinating conversation. I can't thank you enough. Where can people find out more about you? Your social media, your website? Tell us.
So, I have a private Instagram. I'm one of those people that's not so great. My Twitter is open. I don't tweet much, but if you want to find me, you can tweet me, or not even Twitter anymore, X. You can find me on X at Donna Rotunno, my full name. And you can always find me in my office in Chicago.
Fantastic. And I'm your host, Josh Ritter. You can find me on Instagram and X at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, you can also check out my brand new YouTube channel, Courtroom Confidential. And you can, of course, find all of our Sidebar episodes wherever you get your podcasts, and we would love to hear from you. If you've got questions or comments you'd like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you for joining us at the True Crime News Sidebar.